How do you prove negligence in a slip and fall in New York? When you or a loved one is involved in a slip and fall accident, understanding the legal steps to pursue compensation is crucial. Injuries from these incidents can lead to unexpected medical bills and lost wages, making it essential to consider legal action. But proving negligence is not straightforward. The laws around slip and fall cases in New York are specific and require a detailed examination of the circumstances. In this guide, we'll explore how you can prove negligence in such cases, ensuring you have the knowledge needed to build a strong case. Understanding the legal framework in New York. In New York, negligence is a key legal concept used to determine fault in personal injury cases, including slip and fall accidents. To prove negligence, 4 critical elements must be established. Duty. The defendant had a legal obligation to ensure your safety. For example, property owners must maintain safe environments for visitors. Breach of duty. This occurs when the defendant fails to meet their legal obligation, such as neglecting to fix a known hazard. Proximate cause. The breach of duty must be directly linked to your injuries, meaning the accident would not have happened if not for the defendant's negligence. Damages. You must demonstrate that you suffered actual harm, such as medical expenses or lost wages, as a result of the accident. New York also follows a pure comparative fault system. This means that if both parties share some responsibility for the accident, the court will assign a percentage of fault to each. Your compensation will then be reduced by your share of fault. Additionally, New York recognizes gross negligence, which can result in punitive damages if the negligence is particularly egregious. Key steps to prove negligence in a slip and fall case. To build a successful slip and fall case, certain conditions must be met. Hazardous condition. The environment where the accident occurred must have presented a dangerous condition that caused the fall. This could be anything from a wet floor to uneven pavement. Knowledge of the hazard. It must be proven that the property owner knew or should have known about the hazard but failed to address it in a timely manner. Reasonable time to fix the issue. If the hazard developed recently, the property owner should have had enough time to take corrective action or at least warn visitors of the danger. The circumstances of each case will differ, and the evidence you gather will be crucial in proving these elements. A lawyer can help collect evidence, such as photographs, witness statements, and maintenance records, which are vital in establishing the property owner's liability. What is negligence law in New York? Negligence in New York is defined by failing to provide the level of care that a reasonable person would under similar circumstances. In slip and fall cases, this could mean neglecting to repair a known hazard or failing to warn visitors of a dangerous condition. Under New York law, plaintiffs must file their claims within 3 years of the accident. If the property involved is owned by a New York City entity, a notice of claim must be filed within 90 days of the incident. Missing these deadlines can result in losing your right to seek compensation. Challenges in slip and fall cases. Proving negligence can be challenging, especially when determining how much responsibility lies with the property owner versus the victim. For example, if you slipped because you ignored a visible warning sign, the property owner could argue that you share the blame. Common mistakes, such as leaving the scene without collecting evidence or declining immediate medical care, can also weaken your case. It's important to document the scene, report the accident to the property owner, and seek medical attention promptly. Next steps for slip and fall victims. If you've been injured in a slip and fall accident, securing legal representation is vital. A skilled attorney will guide you through the complexities of New York's legal system, helping you understand your rights and the best course of action. At Kucher Law Group, our Brooklyn slip and fall attorneys are dedicated to protecting your rights and pursuing the compensation you deserve. Whether you're negotiating with insurance companies or taking your case to court, our law firm is here to support you every step of the way. Don't navigate this difficult process alone. Contact Kucher Law Group at 929-563-6780 or visit us at 463 Pulaski Street, No. 1C, Brooklyn, New York, 11221, to schedule a consultation and discuss your case today.